Greetings and welcome. I'm Antoinette Delores, qualified expert witness, made in collaboration with the National Indian Justice Center, a nonprofit corporation that provides technical assistance, training sessions, on-site consulting, and publication services throughout Indian country. I'd like to share with you briefly my background. I have been a qualified expert witness since 2012 and work with about 12 counties in Northern California. I retired at the end of 2011 as a CPS social worker of 15 years in emergency response and ongoing services. I was also the Native Services social worker from 2007 until I retired. Before we get started, I'd like to bring to your attention the reference materials that we will utilize throughout the training. If you haven't done so already, I suggest that you go ahead and download these 7 handouts so that they will be available for you. Our goal for this training is to cover topics that will help you identify, understand, recognize, and value the qualifications and role of an ICWA qualified expert witness in child custody proceedings that include the minimal federal and California state standards, who serves as an ICWA qualified expert witness, the benefits for tribes to provide their own ICWA qualified expert witness, the role of an ICWA qualified expert witness, both tribal and independent, the ethical responsibilities of an acting ICWA qualified expert witness, consultation and collaboration between tribes and child welfare workers, the importance of researching the Welfare and Institutions Code and ICWA provisions, the ethics, rules, and conduct of the courtroom, active efforts versus reasonable efforts, the use of the California judicial forms as per California ICWA, the importance of advocacy throughout the process, the need for ongoing ICWA training and education, the process of providing testimony in a written declaration, how to report causal relationship in a declaration, how to report ICWA compliance for active efforts in a declaration, gathering information through the interviewing process and reporting in a declaration. What are the sources of law for ICWA qualified expert witness requirements? These sources of law for ICWA qualified expert witness requirements can be found in this list of resources before you. I suggest that if you are considering to be an acting qualified expert witness, take the time to look up the statutes from these ICWA resources in order to become familiar with the language of the law. Minimum federal standards and California state standards include inquiry and investigation. This is usually the point a social worker will ask a parent or family member if there is any Native American ancestry, or if they are a member or eligible for membership of a specific tribe or tribes. The social worker will then notify any and all tribes that were reported via certified or registered mail. Active efforts applies to ICWA cases, and reasonable efforts usually applies to non-ICWA cases. ICWA and active efforts begin the moment there is reason to know an Indian child is involved. If a petition is filed by the social worker to remove an Indian child from his or her parent, testimony by a qualified expert witness will be needed. Placement preferences are placements approved by the tribe and required for recommendation of foster care adoption or tribal customary adoption. ICWA applies in child custody proceedings that involve foster care, termination of parental rights, pre-adoptive and adoptive placements, and some guardianship placements if a native child cannot be returned to his or her parent upon demand. The purpose of the expert. Why expert testimony is required in ICWA cases. Whenever there is a recommendation for a native child to be placed in foster care, testimony by a qualified expert witness is needed to provide testimony of clear and convincing evidence that returning the child to his or her parent could cause emotional or physical harm. Testimony is required prior to the disposition court hearing. Some counties have the jurisdiction and disposition hearings combined, while others have separate hearings. It is also common for the court to go ahead and take jurisdiction and reschedule a disposition hearing because the court realized testimony by a qualified expert witness was needed. Testimony by a qualified expert witness is also required prior to any recommendation to terminate parental rights that takes place at a 366.26 hearing, also known as a 26 hearing. Whenever there is a recommendation to terminate the parental rights of a native child's parent or native custodian, a qualified expert witness is needed to provide testimony of beyond a reasonable doubt that returning the child to his or her parent is detrimental and could cause emotional or physical damage. Some counties will contact a qualified expert witness prior to the termination of the parent's reunification services. And sometimes a county will contact a qualified expert witness just prior to a 26 hearing. It is strongly recommended that a qualified expert witness review all documentation that active efforts was provided to rehabilitate the parent, but was unsuccessful. Providing testimony for termination of parental rights is serious and a huge responsibility on part of a qualified expert witness. Therefore, it is very important to gather as much evidence as possible from all the legal documents and from interviewing all parties of an ICWA case prior to formulating any testimony of beyond a reasonable doubt. Who can qualify as an expert witness? What to look for in a qualified expert witness? Who is an expert witness? An expert witness has knowledge, skill, experience, training, or education in a particular field, and whose knowledge can assist a judge to use any evidence provided to rule on any matter of a case. Who is a tribal expert witness? Someone with knowledge about the culture, customs, values, traditions, and beliefs of their tribe based on her or his experience, education, skills, and training, and whose knowledge can assist the judge to use any evidence provided to rule on any matter of the case. A A tribal expert witness can be a member of the tribal community with no specialized education. Their expertise is knowledge-based and not necessarily educational-based. The tribe can designate a qualified expert witness to testify as to the prevailing social and cultural standards of the tribe. And sometimes tribes do have their own qualified expert witnesses who can provide evidentiary testimony as well as testifying to the prevailing social and cultural standards of their tribe. Qualifications of a qualified expert witness are defined in both California ICWA and federal ICWA. Please refer to the handout, Comparison of ICWA Regulations, California ICWA versus Federal ICWA, pages 2 to 3. First, I want to explain how to determine if the California ICWA or the Federal ICWA applies. The federal rule number 23.106B states that under the Act, ICWA requires the state or federal court to apply the higher state or federal standard. So let's take a look at page 2 at the top for California ICWA, who may serve as a qualified expert witness. Under the Welfare and Institutions Code 224.6 to C1, 2, and 3, it states, persons with the following characteristics who are most likely to meet the requirements for a qualified expert witness for purposes of Indian child custody proceedings are 1. A member of the Indian child's tribe who is recognized by the tribal community as knowledgeable in tribal customs. 2. Any expert having substantial experience in the delivery of child and family services to Indians and extensive knowledge of prevailing social and cultural standards and child rearing practices within the Indian child's tribe. And 3. A professional person having substantial education and experience in the area of his or her specialty. And provided that any of these individuals are not employees of an agency recommending foster care placement or termination of parental rights, and this would be considered as a conflict of interest. Next, let's take a look at who may serve as a qualified expert witness under the federal rule number 23.122A. An expert witness must be qualified to testify regarding the child's continued custody by the parent or Indian custodian is likely to result in serious emotional or physical damage to the child and should be qualified to testify as to the prevailing social and cultural standards of the Indian child's tribe. A person may be designated by the child's tribe as being qualified to testify to the prevailing social and cultural standards of the Indian child's tribe. Similar to California ICWA, Part C states that the social worker regularly assigned to the Indian child may not serve as a qualified expert witness in child custody proceedings. Also, there is no requirement that the qualified expert witness be a citizen of the child's tribe. However, they should be able to demonstrate knowledge of the prevailing social and cultural standards of the Indian child's tribe, or be designated by a tribe as having such knowledge. The rule also states that ICWA does not limit the number of expert witnesses that may testify. The court may accept expert testimony from any number of witnesses including from multiple expert witnesses. Under the Act, it is also recommended that the qualified expert witness be someone who is familiar with that particular child and meets with extended family members in the child's life. This is important to note. As a qualified expert witness, I make a conscientious choice to at least meet face-to-face with the native child and his or her caregiver. I utilize this meeting to connect with the child, to observe and listen to the child's concerns and their point of view regarding their situation while in care. This is also an opportunity to receive information from the caregiver, how the native family situation has impacted the child emotionally, socially, and sometimes physically. So, after reviewing and comparing the California ICWA and federal ICWA, we discovered that California ICWA has a higher standard as far as identifying those who would best qualify as an expert witness. However, the federal ICWA has a higher standard in recommending that the qualified expert witness be familiar with the native child and extended family members by meeting face-to-face, which is not found in the California ICWA, and therefore at a higher standard. Challenges for an ICWA expert witness. Understanding how different counties vary in applying ICWA. Once you become an expert witness and you start to work with different counties, even though we all live in the state of California, you will discover that counties vary when it comes to applying ICWA law. Locating parties of a case to interview. This can be challenging due to difficulties locating either parent and sometimes having to go through relatives in order to connect with a parent. So interviewing a parent is important as it gives them the opportunity to give their side of the story, as well as to determine compliance with active efforts as to the services that the social worker is providing the parent and assisting them with the reunification process. Preparing a declaration within a time constraint. So there's a rule of thumb with most counties to present to the social worker or to county council a completed declaration within 10 days prior to the date of the court hearing. And with some other counties, 5 days prior to the court date is required. So the purpose of these time constraints is so that all the parties of the case can have the opportunity to review the declaration prior to the court date. Another challenge can be feeling comfortable being asked questions in court and can handle being challenged on cross-examination in court. Active efforts versus reasonable efforts. Active efforts is said to be one of the key standards and protections of ICWA. ICWA and active efforts starts at the time of inquiry, and there is reason to know that the child is an Indian child. The key word that simply describes active efforts is engage. Reasonable efforts are passive, as we discussed earlier. Reasonable efforts are usually developed and practiced by social workers in non-ICWA cases. Let me give you an example of active efforts. A parent is required to attend counseling. The social worker invites the parent to his or her office and assists the parent to make a phone call to the counselor to make an appointment. Afterwards, the social worker asks the parent how he or she will get to the appointment and discovers the parent has no means of transportation. The social worker then provides the parent with bus passes to assist the parent in getting to and from his or her counseling appointment. After the parent leaves the social worker's office, social worker documents in CWS, a statewide system, the service he or she provided to the parent in detail. Using this same scenario, I'll give you an example of reasonable efforts. The social worker gives the parent a sheet of paper with a list of counselors to choose from with their phone numbers. The social worker tells the parent to find a counselor and make an appointment, and then contact the social worker and provide the name of the counselor and the date of the appointment. This is considered as a passive action. Please refer to the handout titled Active Efforts as of December 2016. We will review the Federal Rule 23.2 definitions. Active efforts means affirmative, active, thorough, and timely efforts intended to maintain or reunite an Indian child with his or her family. Active efforts should be provided in a manner consistent with the prevailing social and cultural conditions and way of life of the Indian child's tribe, and should be conducted in partnership with the Indian child and the child's parents, extended family members, Indian custodians, and the tribe. Active efforts are to be tailored to the facts and circumstances on a case-by-case basis. The following are examples of active efforts. 1. Conducting a comprehensive assessment of the circumstances of the Indian child's family with the goal of reunification. Number 2. Identifying appropriate services and actively assisting the parents to engage in those services. Identify and notify the tribal representatives to participate in providing support and services to the Indian child's family, and also to invite the ICWA representative to attend any child-family team meeting or team decision meeting, and also to allow the tribe to assist in clarifying the permanency plan, as well as to work with the Indian child's tribe in any resolution of placement issues. Number 4, conducting a diligent search for the Indian child's extended family members and contacting and consulting with extended family members to provide family structure and support for the Indian child and the child's parents. Number 5, offering and employing all available and culturally appropriate family preservation strategies and facilitating the use of remedial and rehabilitative services provided by the child's tribe. I'd like to clarify that a tribe may assist in providing culturally appropriate services to the Indian family. However, the burden of providing such services is that of the state agency. There are several tribes in California who have community services and are able to provide culturally appropriate services to their families. However, tribes from another state cannot always assist in providing such services due to the long distance of their tribe's location. Therefore, the social worker from California can resort to other local tribal agencies that offer cultural services, such as tribal TANF, tribal health, or tribal family resource centers. Number 6, taking steps to keep siblings together whenever possible. Number 7, supporting regular visits with parents or Indian custodians in the most natural setting possible, consistent with the need to ensure the health, safety, and welfare of the child. Number 8, identifying community resources and actively assisting the Indian child's parents in utilizing and accessing those resources. Number 9, monitoring progress and participation in services. Number 10, considering alternative ways to address the needs of the Indian child's parents if the optimum services do not exist or are not available. Number 11, providing post-reunification services and monitoring. Now, if you could please refer to your handout Comparison of ICWA regulations, California versus federal ICWA, pages 4 and 5. At the bottom of page 4, the federal rule number 23.120 states that prior to ordering an involuntary foster care placement or termination of parental rights, the court must conclude that active efforts have been made to prevent the breakup of an infant family and that those efforts have been unsuccessful, as well as those active efforts must be documented in detail in the record. The rule, therefore, requires that the court has to document active efforts in detail in the record. State agencies also need to help ensure that there is sufficient documentation available for the court to use in reaching its conclusions regarding the provisions of active efforts. So, if you could please refer now to the sample of recording active efforts in a disposition report, pages 1 to 3. So this is a sample how one of the social workers that I worked with, how she documented her active efforts as it pertains to her ICWA case. We will not go over this information step by step. However, I just want to give you an idea about how this social worker designed her active efforts in her court report. So the social worker populated her disposition court report from the DWS system, and then she added a heading of active efforts to her report. It is important to note that not all county social workers provide this type of thorough documentation. However, it is my opinion that it would be best practices to do so, as this type of documentation helps the court to determine that active efforts was provided to prevent the breakup of an Indian family, as well as it assists the qualified expert witness to clearly view the documentation of active efforts and report these findings in the declaration. Qualified expert witness testimony and active efforts. The qualified expert witness is not required by law to prove active efforts. However, as a qualified expert witness, I do base my opinion on testimony that active efforts were provided to prevent the breakup of an Indian family and were or were not successful. A qualified expert witness can be used to meet the burden of providing evidence that active efforts have been provided to establish the tribe's cultural practices. There have been times that I have been called by county council requesting my services to testify that active efforts have been provided to the Indian family. I then inquire if another qualified expert witness previously provided testimony of clear and convincing evidence beyond a reasonable doubt, as required by ICWA. If not, I inform the county council that it would be necessary for me to complete a comprehensive assessment and complete a declaration with my testimony. However, if the previous qualified expert witness provided testimony of insufficient active efforts in his or her declaration, and the agency made the correction, county council's call for my services to testify that the agency met the burden of providing active efforts would require that I examine the declaration as well as examine any documentation of active efforts offered to the Indian family and report those findings in a declaration or attend court to provide my testimony. However, as part of my practice, if this were the case, I would refer county council back to the original qualified expert witness who previously provided testimony, because that qualified expert witness would be familiar with the family and matters of the case. There was a case I worked on whereby I testified on insufficient active efforts and recommended continued services due to the lack of active efforts and preventing the breakup of an Indian family. The family was offered an additional 6 months of services, and County Council contacted me once again to conduct another assessment and provide testimony in another declaration. Benefits of tribal and independent qualified expert witness. This is about collaboration and building relationships. There is a benefit in establishing a relationship with County Council that supports open and honest communication and allows an opening for any necessary negotiations. The independent qualified expert witness can also be a bridge or liaison between tribal and county workers. The tribal qualified expert witness can express and support tribal sovereignty, which can then empower and strengthen the tribe's self-reliance and affords the tribe greater involvement in the legal process, as well as it affords the tribe to have a voice for the record. Building relationships. One of the important elements of building a working relationship is establishing a foundation of commonality. Dependency cases include parents, children, caregivers, extended family members, tribal agencies and staff, social workers, county council, service providers, attorneys, and qualified expert witnesses. What do they all have in common? They serve families and children and offer assistance that is in their best interest to keep their family intact and share a similar goal to help unify the Indian child with his or her family. The qualified expert witness establishes a relationship through the consultation and interview process during contact with the parties to the case. The qualified expert witness establishes rapport when working in collaboration with the tribe and state agency through this process, and that he or she can assist the agency or department to be ICWA compliant, which supports a positive outcome, such as reunification, permanency, or transfer of jurisdiction to a tribe. Relationship building can also be established through education and networking. For example, as a qualified expert witness, it is not unusual that I find myself informing social workers on matters of ICWA that assist them to be ICWA compliant, providing them with information for local Indian services in their area. My thought of practice is that when I help a social worker on clarity of ICWA law, that social worker benefits from such knowledge, which is then transferred to benefit the Indian family to succeed in reunification. Best practices as to a qualified expert witness. Integrity. No delimitations. Let me explain. Once you become established as a qualified expert witness, you could experience many phone calls requesting your services. It is important for your own self-care to know how many cases you can easily contract to complete a declaration without becoming too overwhelmed. This is about integrity to yourself and to the state agency, or if you take on too many cases, it can compromise your quality of work. Honor and support sovereign nations. For example, whenever my services are requested by the social worker or county council, I always ask if they have already contacted the tribe first to see if they have their own expert witness. If they say no, I will request they do so and then get back to me. And sometimes I will be told the tribe was already contacted and they were okay in seeking an independent qualified expert witness. If I am informed that a tribe has their own expert witness, but the agency wishes to seek their own qualified expert witness, as a matter of respect, I will graciously decline the services with an explanation as to why. Cultural competency. A tribal qualified expert witness can give testimony as to the prevailing social and cultural standards of their tribe. However, if a tribal qualified expert witness is not designated by the tribe, then it is the responsibility of the independent qualified expert witness to gather information from the tribe they are working with to acquire information on their prevailing and cultural standards. Respect and empathy. Professionalism. Agree to disagree. It is okay to disagree on some particular aspects of the case. However, do so professionally. Be neutral. Some county agencies have a misunderstanding that because they contract with an independent qualified expert witness, that person will provide testimony that supports their own recommendations. It is important that as a qualified expert witness, you do not fall into this kind of situation. According to ICWA, the state agency has the burden to acquire a qualified expert witness for testimony as well as purchase their services of a qualified expert witness. Think of yourself as being in the middle, with the tribe on one side of you and the state agency being on the other side. Being in the middle, the qualified expert witness has the opportunity to gather information from both sides and then provide a sound testimony and a declaration. Know the unknown. Seek to know. It is okay not to know, but it is then the responsibility of the qualified expert witness to seek the information in order to know. As recommended in the federal ICWA regulations, meet face-to-face with the children, become familiar with them whenever possible, interview all parties to the case in person or by telephone, including any caregivers of the minors, engage in consultation with the tribal ICWA representative, share cultural or other resources with parties to the case, and honor confidentiality at all times. Build a network. As a qualified expert witness, I have built a network of consultants that includes ICWA attorneys and other ICWA expert witnesses with whom I can seek advice whenever I am uncertain as to how I can apply ICWA on a particular situation of case I'm working on. It is important to note that due to confidentiality, I discuss in generic terms without giving any specific names or locations in order not to breach confidentiality. Cultural resources. I have also established rapport with many service provider agencies, both native and non-native, from various counties, to learn of their services and how to access them. I then share this information usually with the social worker. Avoid cookie-cutter opinions. Remember, every case is different, so it is important to tailor your opinion to each individual case you are working on. Avoid making assumptions. A qualified expert witness's opinion or testimony is based on facts and not assumptions. This supports the importance of interviewing as many parties to the case as possible. Allow the time needed to provide an authentic opinion. Remember, your declaration is due to the social worker or to county council 5 or 10 days prior to the disposition or 2-6 court hearing. So it is important to know your own timing process that it takes for you to gather all of the necessary information that you need in order to develop an authentic opinion. Duties of an expert witness. Compensation, duty of a potential expert, and procedure. Handling of legal documents. Confidentiality. I cannot express enough the importance of confidentiality. As a qualified expert witness, you will receive several packets of important legal documents. It is important that these documents are kept under your security and away from areas in view of others to see. We will now review the list of confidential documents which you, as a qualified expert witness, can request from the state agency for review. They are investigative narrative, custody warrant, petition, court reports that include detention, jurisdiction, disposition, status review, addendum, case plans, court findings, case notes that fall under the heading of Delivery of Services log located in the CWS statewide system. I usually ask for copies of this information that dates back to the beginning of the case to the present date of the time that my services are requested. Proper disposal of documents. The tribal qualified expert witness will abide by the tribe's practices of how they handle these legal documents. They will either want them to be filed or else they will shred them. For a non-tribal qualified expert witness or an independent expert witness, these legal documents should be shredded properly. For example, seeking a company that is in the business of shredding legal documents or mailing the documents back to the agency. It is not recommended that you use your own personal shredder, as you will discover that shredding about 1,000 pages per case will soon wear out your shredder, as well as it could also be time-consuming. Judicial counsel forms. Here is a list of forms that is required under California ICWA. The JV-100. This is a petition that lists any and all allegations of a parent. And attached to the petition is the ICWA 010A form for each child that must be filled out completely and filed with the court. The ICWA 030 must be completed by the social worker. This form is used as part of the process to notify all tribes reported by the parents or extended family members and sent to the tribes via certified or registered mail. The ICWA 020 is usually provided to the parent to complete at the detention hearing. However, if the parent is not present at this hearing, the social worker will provide this form to a parent when possible. The ICWA 040 and 060 are completed whenever a tribe requests for a transfer of jurisdiction. So at this point, I suggest we take a little break, and then we will come back and return to the remaining part of the training. The interviewing process. Please refer to the handout ICWA Qualified Expert Witness Review Checklist. This is a checklist that I developed to assist a qualified expert witness in what to look for once receiving all of the packets of documents from the state agency. So this is meant to use as a guide. Next, please refer to the handout, ICWA Qualified Expert Witness Interview Question Guide. So these are just samples of questions to ask when you are interviewing the child, the caregiver, the social worker, county council, each parent, and the tribal ICWA representative. So just use this as a point of reference. There may be other questions that you will come up with that would pertain better to the case that you are working on. So this is just merely an example of interview questions that I use and to be used just as a reference. The ICWA Declaration. Please refer to your handout that is a sample of the Declaration. The title is Superior Court of the State of California for the County of, and then it has in parentheses the name of the county. At the beginning of your declaration, you will write the case information such as the child's name and the case number. Next, you will write a summary of your qualifications and experience as a qualified expert witness, which I recommend that you keep to a maximum of 4 pages. Next, you will summarize the tribe's history, culture, customs, and traditions. And then you will also list all of the allegations from the petition verbatim, meaning as they are written in the petition. And then you will list all of the documents that you reviewed, which were sent to you by the state agency. Next, you will report the evidence of who stated what and when. So while you are interviewing the parents, the children, caregivers, relatives, county social worker, and the ICWA representative, it is important to take notes on the dates that you spoke with them and their statements so that you can record as close to verbatim as possible. Report ICWA compliance and non-compliance, active efforts, and services offered to prevent the breakup of an Indian family which were successful or unsuccessful. An example of compliance would be that the social worker made contact with the tribal representative and engaged in consultation and collaboration on all aspects of the case. An example of non-compliance would be the agency failed to properly notify the tribe as the agency did not complete the ICWA 030 form and mail it to the tribe via certified or registered mail. However, after this qualified expert witness brought this matter to the state agency's attention, the social worker reported that the matter was to be addressed and rectified in a prompt manner. So after you have compiled all of your information that you have gathered and the statements that you gathered from parties of the case, you will next need to report on the causal relationship based on the evidence that you found. After this, you will formulate an opinion of clear and convincing evidence or evidence beyond a reasonable doubt. At this point, I would like to discuss in further detail about the causal relationship. So if you would refer to the handout titled Reporting Causal Relationship in a Declaration, there are 4 samples that I provide you in how to report the causal relationships. But first of all, I'd also like for you to please refer to the handout Comparison of ICWA Regulations, California ICWA versus Federal ICWA. On page 4, in the middle of the page, it talks about the Federal ICWA standards of evidence. the Federal Rule number 23.121 B and B. So the language within this rule is new. So let's take a look at it in Part C. For a foster care placement or termination of parental rights, the evidence must show a causal relationship between the particular conditions in the home and the likelihood that continued custody of the child will result in serious emotional or physical damage to the particular child who is the subject of the child custody proceedings. D. Without a causal relationship, evidence that shows only the existence of community or family poverty, isolation, single parenthood, custodian age, crowded or inadequate housing, substance abuse, or non-conforming social behavior does not by itself constitute clear and convincing evidence or evidence beyond a reasonable doubt that continued custody is likely to result in serious emotional or physical damage to the child. So if you can refer now to the reporting causal relationship in a declaration, we'll look at sample 1, and you can look at samples 2 to 4 on your own time. So this is a particular case that I worked on. The child had been diagnosed with PTSD, which I found that the diagnosis was made for him merely through hearsay. In other words, it was based on what the foster mother was reporting to the therapist, and the therapist did not see the child at all. So in my report, I wrote that there was lacking information that could explicitly identify and explain the source of his behaviors, such as direct observation and assessment, and not merely through reporting or other indirect or outside resources. So I saw this as based on hearsay and without a proper assessment with a professional. So the mother also had allegations of substance abuse. However, there was no evidence of present time substance abuse. There was also no documentation of history of substance abuse, as there was no evidence of any positive drug test or its results documented by the police department or by the state agency. And it seemed to be subjective, as only through possible observation. In other words, in the police report, it said that she appeared to be under the influence of a substance. However, evidence did show that the mother had issues with improper and inadequate supervision of her son more than once, which placed him in harm's way. So there was documentation that the child had escaped the home on 2 or 3 occasions and nearly went out into a busy intersection that was located right outside of the home. So the mother's inadequate and improper supervision is what placed him in harm's way, and was evidence of a causal relationship between conditions in the home and the likelihood that continued custody of the child would result in serious physical or emotional damage. So the fact that the mother was providing inadequate supervision with regards to this particular case is what is the evidence of causal relationship. So then when I made my formula for testimony, I put, therefore, based on review of the reports and contact with the above persons, as well as my training and experience, and as set forth above, pursuant to the Indian Child Welfare Act, it is my opinion there is clear and convincing evidence that continued custody of the minor by the mother would likely result in serious emotional or physical damage. So when this child on the third time ran out of the house, he had no clothes on, he was barefoot, and his foot was bleeding. And it was a citizen who found the child and contacted the police, which is what brought this case to the attention of the state agency. And since this was not the first time, but rather the 3 occasions that this occurred, the third occasion actually elevated to a more dangerous situation. Therefore, this is how we report the causal relationship when writing our declarations and making our opinions and providing testimony. Expectations of the court. So the qualified expert witness will be providing testimony in a written declaration, and there are times that the qualified expert witness will be requested to attend court either in person or by phone. Qualified expert witness is also to provide the written declaration 5 to 10 days prior to the hearing date to county counsel or to the social worker, whichever is the provision of the state agency. So if the qualified expert witness is to appear in court by phone or in person, that person should speak or respond only when addressed by the court. And also, it is proper to address a judge with respect, with the phrase, Your Honor, whenever responding to a judge's question or comment. So let's talk about court preparation. So it's important to prepare for cross or direct examination by reviewing reports, using your declaration. I also suggest that if you are going to appear in person, that you take to court with you a copy of your declaration so that you can refer to it if need be while you are on the stand. Also, for court appearances in person, it is important to arrive 10 to 15 minutes early, but on time, and to wait outside of the courtroom. You will usually be greeted by the county counsel. You can follow their lead, or once you enter into the courtroom, you can ask where you are to sit. So if you are requested by the county or by county counsel to appear in court by phone, it's important to consult with the social worker or county counsel and to request for the information needed to call into the court on the date of the hearing. It's also important to verify the date and the time and the department. You will be asked these questions once you call in to appear by phone. It's also important to verify if the court will call you, the qualified expert witness, or if you will need to call in. I find that most commonly I'm the one that has to call in. And once I call in, then I'm asked to wait and I'm placed on hold. It is also not uncommon to be placed on hold for hours at a time. I think the most that I had to wait on hold prior to speaking with the judge was 4 hours. And once I got online with the judge, it went rather quickly after that. Ongoing training. So it is very beneficial to participate in as many trainings as possible. Most trainings I find are either low cost or are free. And the benefits of attending as many trainings as possible is to stay informed on ICWA changes to the Welfare and Institutions Code, and on accuracy of reporting evidence and formulating opinions. So sometimes there are changes, particularly with the Welfare and Institutions Code and to the codes of the Judicial Council. So what I do is annually, I go through the codes that I used quite often in my work as a qualified expert witness to see what updates there are at the beginning of the year. And I recommend that you do so as well, because a lot of times there are updates on these provisions. And the frequency of training, I suggest that you attend as often as the opportunity arises. So some of the training resources are the Travel Star, the National Indian Justice Center, the American Indian Child Resource Center, California Indian Legal Services, ICWA, ICWA Info, North, or attend an annual ICWA conference or conferences through the Judicial Council of California. Have your name on the Qualified Expert Witness State list. So once you decide that you want to be an acting Qualified Expert Witness, I suggest that you contact the Judicial Council of California at 415-865-4200 and ask to speak with the staff person who is responsible for adding names to the state's ICWA Qualified Expert Witness list. The list includes qualified expert witnesses who work with the different regions of California. That include the southern region, the central region, and the northern region. So it's going to be important for you to clarify with the person that you speak with from the Judicial Council which region that you prefer to work in. Also, you do not need to provide a resume when you are asking your name to be placed on the Qualified Expert Witness. However, once you are contacted by any state agency in California, they will request a CV or a resume from you, at which time then you will provide that to the county that is requesting your services. So we have come to the conclusion of this training. It is my sincere hope that this information on the ICWA Qualified Expert Witness is of value for you and helpful as to the requirements and role of a qualified expert witness. I appreciate your time in participating in this training.